Former employees of the Richmond County Marshal's Office, Mallory Jones and Troy Moses, filed a lawsuit in 2018 against Augusta Richmond County and the new marshal-elect, Ramon Lampkin, alleging wrongful termination. They claim that they were fired on January 1 with no legitimate reason other than their support of outgoing County Marshal Steve Smith, who lost to Lampkin in the election. Jones and Moses assert that their termination was in retaliation for exercising their First Amendment rights of freedom of speech and association. They argue that Lampkin's decision to terminate them while not yet in office does not afford him 11th Amendment immunity. They also believe that Augusta Richmond County failed to prevent Lampkin from taking action against them and that the county government has the power to protect employees' First Amendment rights. Jones, who served as captain of the Marshal's Office for 24 years and earned $71,100 annually, and Moses, who was recently promoted to sergeant and earned $46,700 for approximately 8 years, claim that they lost their seniority and will have to seek entry-level positions with substantial pay cuts as a result of their termination. The lawsuit was denied summary judgment, meaning that Jones and Moses lost their case. As of April 2022, they are currently employed by the Richmond County Sheriff's Office. Mallory Jones is actively employed by the Richmond County Sheriff's Office as of April 2022. Jones is assigned to the Road Patrol Division and now makes $50,594.93, that is a $20,400 pay cut. Troy Moses is actively employed by the Richmond County Sheriff's Office as of April 2022. Moses works in the Jail Division and now makes $47,704.03, a pay increase of $1,000. In this case, Mallory Jones and Troy Moses are asserting their First Amendment rights to free speech and association as the basis for their wrongful termination claim. The First Amendment protects an individual's right to freedom of speech and association, meaning that the government, including public employers like the Richmond County Marshal's Office, cannot take adverse employment action against an employee for exercising those rights. However, it is important to note that government employers can limit employees' First Amendment rights when there is a legitimate reason related to the functioning of the government agency. This is known as the Pickering balancing test, which balances the employee's interest in speaking out against the government agency's interest in maintaining an efficient and effective workplace. In this case, Jones and Moses are arguing that their support of outgoing County Marshal Steve Smith was a protected exercise of their First Amendment rights, and that their termination was in retaliation for that protected activity. They are also arguing that Lampkin's decision to terminate them while not yet in office does not afford him 11th Amendment immunity, which protects government officials from lawsuits brought by private individuals in certain circumstances. Summary judgment was granted to Lampkin. Summary judgment is a legal ruling that can be granted by a court before a case goes to trial. It is a decision made by a judge based on a motion filed by one party in a lawsuit asking the court to rule in their favor because there are no material facts in dispute and the party is entitled to judgment as a matter of law. Essentially, summary judgment allows a judge to make a ruling on a case without the need for a full trial. To grant summary judgment, a judge must determine that there are no genuine issues of material fact in the case and that the moving party is entitled to judgment as a matter of law. This means that the judge must determine that there are no disputed issues of fact that would require a jury to make a decision, and that the moving party is entitled to win the case based on the law and the undisputed facts. If a court grants summary judgment, it means that the case will not proceed to trial and the party who filed the motion will win the case. However, if the court denies summary judgment, the case will continue to trial where a jury will determine the outcome based on the evidence presented. Here are some examples of cases where lawsuits for wrongful termination based on First Amendment rights have been successful. Pickering v. Board of Education, 1968. This landmark Supreme Court case established the Pickering balancing test, which balances the employee's interest in speaking out against the government agency's interest in maintaining an efficient and effective workplace. In this case, the court ruled in favor of a teacher who was fired for writing a letter to the editor of a local newspaper criticizing the school board's budget decisions. Here are some examples of cases where lawsuits for wrongful termination based on First Amendment rights have been successful. Pickering v. Board of Education, 1968. This landmark Supreme Court case established the Pickering balancing test, which balances the employee's interest in speaking out against the government agency's interest in maintaining an efficient and effective workplace. In this case, the court ruled in favor of a teacher who was fired for writing a letter to the editor of a local newspaper criticizing the school board's budget decisions. Givhan v. Western Line Consolidated School District, 1979. The Supreme Court ruled in favor of a teacher who was fired after complaining to her principal about the segregation of teachers at her school. The court held that the teacher's speech was protected by the First Amendment because it addressed a matter of public concern. Connick v. Myers, 1983. In this case, the Supreme Court ruled against an assistant district attorney who was fired after circulating a questionnaire about office morale and the handling of a particular case. The court held that the speech was not protected by the First Amendment because it did not address a matter of public concern and the potential disruption to the office outweighed the employee's interest in speaking out. These cases illustrate the importance of the Pickering balancing test and the need to balance the government employer's interest in maintaining an efficient and effective workplace with the employee's First Amendment rights. When an employee's speech is determined to be protected by the First Amendment and the employer's interest does not outweigh the employee's interest, a lawsuit for wrongful termination based on First Amendment rights may be successful. Garcetti v. Ceballos, 2006. In this case, the Supreme Court ruled that a government employer could discipline an employee for speech made as part of the employee's official duties. However, the court also noted that speech made as a citizen on a matter of public concern is protected by the First Amendment. Here are a few related stories you may find useful. In 2020, a former police officer in Indiana sued the city of Kokomo, alleging that he was fired in retaliation for his support of the mayor's political opponent. The lawsuit claimed that the officer's First Amendment rights were violated when he was fired for attending a political rally and expressing his political beliefs. In 2019, a former employee of the Montana Department of Corrections sued the department, alleging that he was fired in retaliation for his political beliefs. The lawsuit claimed that the employee was fired after he expressed support for a political candidate on his personal social media account. In 2018, a former employee of the Georgia Department of Public Health sued the department, alleging that she was fired in retaliation for her speech on a matter of public concern. The lawsuit claimed that the employee was fired after she raised concerns about the department's handling of a data breach and spoke to the media about it. In 2017, a former teacher in New York sued the school district, alleging that she was fired in retaliation for her speech on a matter of public concern. The lawsuit claimed that the teacher was fired after she spoke out against the district's handling of a sexual harassment complaint and advocated for the rights of sexual harassment victims. These stories highlight the ongoing issues surrounding free speech in the workplace and the potential for employees to face retaliation for expressing their political beliefs or speaking out on matters of public concern. To summarize, Mallory Jones and Troy Moses, former employees of the Richmond County Marshal's Office in Georgia, have filed a lawsuit alleging that they were wrongfully terminated by the new Marshal-elect Ramon Lampkin for supporting the outgoing County Marshal Steve Smith during the election. Jones and Moses claim that their First Amendment rights to free speech and association were violated, and that Lampkin's only motivation for terminating them was retaliation. They also believe that Augusta-Richmond County allowed Lampkin to take action and terminate them. The case was denied summary judgment, and as of April 2022, Jones and Moses are employed by the Richmond County Sheriff's Office. This case is just one example of ongoing issues surrounding free speech in the workplace and the potential for employees to face retaliation for expressing their political beliefs. Thank you for watching this video and taking the time to learn more about the ongoing issues surrounding free speech in the workplace. It is important for us to be aware of our rights as employees and to stand up for our beliefs, while also recognizing the potential for retaliation and seeking legal recourse when necessary. I hope this video has been informative and helpful, and if you have any further questions or comments, please don't hesitate to reach out. Thank you again for watching.